Hello, thank you very much for coming. Thank you, all of you, for following us in this new table, in this new panel within the IDP conference. Our uh, mm, approach to the developments in the digital realm and covering different issues on law and politics related to the information society. We are going to have a very interesting panel with on the one hand, Martin Husovets. He's an assistant professor at the Department of Law at the London School of Economics. We will also have Alexandra Kucherave, who's a postdoctoral researcher at the Center for IT at IP Law at the University of Leuven. Also, Gloria González Fuster, who is a research professor at the Faculty of Law and Criminology at the Free University of Brussels. And we will also have the keynote speaker who has already delivered a keynote speech in the previous session, which is available for you to download and to watch in the website, who's Pedro Hinojo. Pedro Hinojo González is a member of the Spanish Authority of Market and Competition, and who deals mostly with the competition aspects of the issues we will go into to be talking about. So this panel is intended to deal with issues which are relevant for platforms, for online gatekeepers, and we are in the midst of new legislation in the pipeline. So we have this package of both the Digital Services Act and the Digital Markets Act, and of course some other elements, some other instruments of legislation which are affecting very much the platforms and this online gatekeepers, and including as well very relevant developments in the case law field, so including new cases in copyright, also in defamation, also in data protection. I'm thinking mostly of the Court of Justice of the European Union with recent and very relevant cases. And so we are in a way preparing for this, for the emergence of this new digital single market to be a reality. So the approach of this panel would be touching upon different issues. So Martin, in the first place, will deal mostly with copyright issues. Then Alexandra will tackle mainly free speech, freedom of speech issues related with the use of platforms and social networks. And then Gloria González Fuster will tackle issues of data protection, maybe also from the point of view of competition and so on. Then finally, we will have a Q&A and a discussion. We will be accepting, of course, any question you may put through the YouTube player. And also we will discuss, depending on how things are going on in the speeches. And for that debate, we will have, and that's why he's also here, Pedro Hinojo, who will also provide this input mostly from the economics and competition point of view. So that's the program for this afternoon. So first, I will like to very briefly introduce Martin. Martin Husovets is a very well-known scholar in the field of intermediary liability, particularly in the field of injunctions and different measures to regulate and to react or to somehow organize the the field of intermediaries, considering all these new business models, and he has authored a lot of works, including several books which are really relevant in this field. And he will start by tackling issues of copyright. So the floor is yours, Martin. And again, thank you very much for having accepted to be here with us. The floor is yours.
Thank you very much, Miguel. Thank you for this very kind introduction. It's a great honor to be here today with you. So I was thinking, what would be the most interesting that I could say in the format of this conference? And given that this will be a panel where we'll then later discuss, I thought I'll try to say something about copyright law, but at the same time say something that interfaces with freedom of expression and data protection law, data protection case law, so that we can have a nice conversation later. So what I'll do is I will make a couple of high-level remarks about rebuilding EU digital single market, which is the title of this session. So copyright is special. That seemed to have been the case 20 years ago, because if you think about this, and Miguel has written about this a lot, the DMCA, that is basically the backbone or the blueprint for our e-commerce directive model, is the regulation of copyright. And the reason why copyright law started thinking about the regulation of platforms so early, perhaps before we called them platforms, really, we just called them intermediaries, which seems a little bit more boring, was the fact that the copyright law tried to tackle the problem of dual use technologies. So basically, technologies that can be used for ill and good. And the question was how to draw the line, how to say when a tool becomes illicit and whether the tool is actually socially useful, so we should keep it and it should remain legal. And we have many cases about this. Many of your common technologies like VCR and others were litigated on this ground. So this was the basis of regulation of platforms from 20 years ago. And we lived in this world where we basically developed a model of what we call notice and takedown, where basically right holders in the copyright realm had to notify the platforms about some particularly infringing content, and the platforms had to make a decision about taking it down. Now that has changed with the reform in 2000 that was initiated in 2016 and somewhat completed in 2021 when the directive entered into force. I'm talking about the DSM copyright directive, which included a special regime for a subset of platforms, a subset of hosting providers that we call online content sharing service providers. Basically, we think of YouTube and similar services. And the change that this has brought was that instead of relying on the notice and takedown system, we have switched to what probably would be most simply described as licensing first and model, where right holders can opt out of licensing into notice and stay down. And notice and stay down basically means that instead of right holders having to send notification about a particular legal content all the time, now they just have to send a single notice that also includes some fingerprints and some other information that could help then the platform to prevent a recurrence of the infringement in the future. So this is the model that we have developed for YouTube and the like services. Now the interesting thing is that what happened in the meantime was that all the other services outside of the ambit of the special rule in Article 17 of the DSM copyright directive remained under the old system. And the old system was really interesting because we had the notice and takedown, which was built around the hosting safe harbor. But basically, the entire regulation of these dual use services was left to the national law because the European legislature didn't want to step in and regulate what we call secondary liability. Now, 20 years later, the Court of Justice, in its ruling just from the last week, I believe, in the YouTube Peterson case, basically finally entirely changed that. So after 20 years, with some 10 years of case law where it was hesitating whether to intervene by sort of being activist and expanding secondary liability, and acknowledging it several times that this is not harmonized, then doing something a little bit more than was envisaged. Finally, actually went all the way up to developing the basis of future EU secondary liability and copyright law. So now actually the court filled in the gap of a legislature that was hesitant, actually not hesitant, it was totally avoiding the issue for 20 years in all the areas of IP, not only in copyright law. So we kind of remain now in this interesting spot where on one hand we have this copyright law now that will have to develop through judiciary its own accessory liability standards. And on the other hand, we have the special regime of Article 17. Now, the big question about Article 17 that remains, and particularly about a stay down, is whether that's in line with fundamental rights. And there is a pending challenge initiated by Poland saying that the stay down as envisaged by Article 17 is unconstitutional. Now, the interesting bit about that is why it might be unconstitutional. And the argument obviously is that automation is being forced on the platforms, that somehow is leading to censorship because even legitimate content will be taken down. Now, what I think is interesting is that if you think about this problem, and if you agree that some automation might be possible and that the legislature can decide to incorporate automation into the law, then the question becomes, what kind of safeguards have to be there to prevent abuses from taking place, so for overblocking from taking place? And there you have two basic types of safeguards: ex ante, ex post. Ex ante meaning before something is blocked, ex post meaning after something is blocked. Now, these are procedural safeguards. And interestingly enough, if you look at the directive itself only deals with ex post safeguards. Even with those safeguards, it's actually very vague about what the member states have to do. It doesn't include anything about ex ante safeguards, meaning if something else is automatically blocked, should there be any supervision of technology and its accuracy, or human review or something like that. Now, interestingly enough, if you look at the latest guidance of the European Commission itself seems to admit that in case the blocking is automated and there is no dispute around something being blocked before it's taken down, there should be human review. So they kind of admit that the constitutionality of this assumes that there are some ex ante safeguards which are not in the directive itself. And that brings me to a very interesting question that is very important for the digital single market, also for the DSA, which is, if you think about it, if you agree with the Commission, which I tend to, that ex ante safeguards are necessary if you want to have a solution like Article 17, then the question is whose job it is to introduce it. Can the EU legislature say that it's up to the member states to do it? Or is it the obligation of the EU legislature to do it on the union level? And my opinion is that it's the obligation of the EU legislature to do it. And if there is a reason why Article 17 might not survive, I think this might be the one. Which is, I think, actually needed point for the development of union legislation, because we see other pieces of legislation where also similar schemes of delegated enforcement are being introduced, and there's a lack of safeguards. Everything is being outsourced to the member states level, because of course member states can fix it. The question is, will they? And I think here, actually, we should look at the data protection case law, because Digital Rights Ireland is the first case to actually clearly suggest that it's the EU legislature's central responsibility to include safeguards on the union level in the union legislation. You cannot just outsource it to the national level. So the question now is, does Digital Rights Ireland bring us as far as to say that Article 17 is possibly unconstitutional because ex ante safeguards are missing? And that's a key question. And I think the other interesting issue with this is that if you think about a Digital Single Markets Act, Digital Single Markets Act is everything that Article 17 isn't. Namely, it is an internal market measure that is 70% about fundamental rights. It's about safeguards. Basically, most of the DSA is about safeguards. And interestingly enough, even though it's actually building around the notice and takedown system, it does not only include ex post safeguards, meaning complaint, redress mechanisms and ADRs and similar mechanisms. To the contrary, it actually includes ex ante safeguards. For instance, with the most obvious one is the risk mitigation measures, which are seen by many only as a provision that will somehow deal with the harmful but illegal content, or will impose obligations in the area of other harms that is actually unlawful, that are systemic. But also, actually, it can be also used as a measure to force the platforms to improve their freedom of expression compliance when it comes to overblocking. So I think it's quite interesting to see the DSA and to look at a DSA, because you could with a little bit of a stretch, call it basically GDPR-like set of procedural safeguards for freedom of expression and due process when it comes to the removal of illegal content. And I think that's quite interesting development in internal market law, and I think quite a welcome one, because what we have seen so far was a patchwork of local and sectorial regulations that try to resolve the enforcement issue, but never the safeguard issue. And suddenly now we have a horizontal measure that tries to resolve that, including for copyright. And that's the most curious thing, that even though the DSA is not far-reaching in any sense in terms of enforcement compared to the status quo, it's much more far-reaching when it comes to safeguards compared to much more far-reaching pieces of legislation such as Article 17. Okay, and with this, I stop.
Thank you very much, Martin. I think we will have time to discuss about many of these issues. So particularly the maybe new approach of the Court of Justice on these issues, and particularly with regard to freedom of expression, as is more prominent in this new ruling on YouTube and Peterson case. So now we will move to other issues with Alexandra Kucherave. She is a postdoctoral researcher at the Center of IP and IT and IP at KU Leuven. She has done a lot of research in the field also of intermediary liability and the rules on freedom of expression and human rights in relation with the dissemination of information within social networks and generally on the internet, among other things. So the floor is yours, Alexandra, and thanks again for joining us.
Thank you, Miguel. Thank you for the invitation and for such a nice introduction. And thank you, Martin, also for warming up the topic and actually mentioning safeguards. I will continue on that. But let me just share my screen. I actually have some slides for you. Okay. So free speech or freedom of expression. So the topic of our panel today is gatekeepers. And this is a picture that I used a while ago, and I was very happy that I could bring it back on the concept of gatekeeping, right? It is not a new one. It was in a way introduced by Kurt Lewin in 1947 to describe the role of wives and mothers in deciding to what food to put on the table. And that was actually following a campaign addressing women to buy secondary cuts of meat and leave lean meats for American soldiers during the war. And according to this theory, it is the gatekeepers who decide what to reject and what to allow through a gate, and effectively deciding what goes through the channel, controlling the movement within this channel. But the gatekeeping model goes far beyond food choices. And that can be also, let me just, okay. And It applies also to traveling of information through communication channels. So for example, in media, it is a publisher or editor who decides which story to feature and which to ignore. So basically which story to let through the channel so it reaches the audience. So it very much the focus here is on the information power. But it can also be applied to internet intermediaries who are often seen as natural points of control, on the internet. And this is because they have technical capacity to stop certain activities of wrongdoers and very often identify people behind these activities. And with such power in their hands, they become natural candidates for the role of gatekeepers. Because of these technical abilities of intermediaries, states enlist them directly or indirectly infringing and illegal content online. Is it okay? Okay. And they do it by delegating traditional policing functions to the intermediaries. But as a result, they strengthen the power of intermediaries to impact the effective exercise of the right to freedom of expression of the internet users. So the definition of gatekeepers is included in the Digital Markets Act. Article 3 addresses the designation of the providers of large platform services as gatekeepers, and that very much focuses on the market power. And it is long and very detailed provision, but that's not what I'm going to talk about. I want to talk about Digital Services Act, which I think has more direct relevance for the discussion on the freedom of expression. Okay. Yeah, so of course, these two acts should not be considered in separation from each other, but I think, that this is what I would like to focus on. And the interesting here is that the Digital Services Act does not use the term gatekeepers. It contains layer provision addressing different types of or different levels of intermediaries. So all intermediaries, hosting services, online platforms, and very large online platforms. It creates different levels of obligations depending on under which category a service provider fits. The DSA aims to amend the old rules of the e-commerce directive. And the goal is to rebalance responsibilities of users, platforms, and public authorities according to European values. And as Martin already mentioned, the DSA clearly states the goal is to ensure more protection for fundamental rights, and in particular, freedom of expression. For example, Recital 3 says that responsible and diligent behavior of providers ensures effective exercise of the rights guaranteed under the Charter, and specifically listing here freedom of expression. But there are also other recitals, 22, 41, 42 as well. So the explanatory memorandum to the DSA clarifies that the rules on intermediaries built on the e-commerce directive. The proposal reproduces the old articles 12 to 15, basically, which are now 3, 4, 5, and 7, but also provides some additional clarification. For example, stating clear notice and action procedure and not merely implying it like the directive did. But in general, DSA replicates the conditional liability regime for third-party content by the directive. So hosting service providers can benefit from a liability exemption if they don't have knowledge of illegal activity. As regards claims for damages, are not aware of facts or circumstances from which this illegal activity is apparent. And when obtaining such knowledge or awareness, they expeditiously remove or disable access to this information. And under this regime, hosts are not obliged to take down anything, but they're offered legal immunity in return for assisting states in achieving its public objectives. And in theory, they do not have an obligation to act, but in a situation when they risk being held liable for their users' activity, it's not a big surprise that they implement a variety of measures to restrict speech. It's also not surprising that they might be too quick to take down content, which puts them at risk. And effectively, the regime places intermediaries in position to decide which content can remain online and which should be removed. And while the delegation of powers to private entities may be considered as efficient or effective method to tackle illegal content, it also raises several concerns. States' tasks that are delegated to entities that are not competent to make this type of decisions. There is no proper balancing of rights at stake. It may lead to over-removal of legal content. So it actually affects fundamental rights of internet users, and in particular lead to undue restrictions to speech through private censorship. Building on the basis of the known rules of the e-commerce directive is of course beneficial from the perspective of continuity. But it also seems to replicate some of the previous weaknesses of the directive. For example, with regard to clarity of the rules. So one example here is that DSA does not clarify the difference between actual and constructive knowledge, which was often criticized under the directive. Also, it definitely does not require court order to create actual knowledge, which is something that in some of the member states, that's the requirement, and in general, that was advocated for by a number of commentators, academics, or civil rights organizations. What the DSA does, as also Martin mentioned already, it introduces a number of safeguards to strengthen protection of the right to freedom of expression or to facilitate its effective exercise. And this is in line with the theory of positive obligations, according to which states or legislator not only should not interfere with fundamental rights of its subjects, but also has a positive obligation to effectively protect it, to protect the rights, also from interference by other private individuals. So the DSA contains a number of substantive and procedural safeguards. For example, safeguards strengthening procedural fairness of the clarified notice and action mechanism. So for example, I will just mention some, where hosts decide to remove or disable access to specific content for whatever reason, it should inform the recipient of his service of that decision. At the latest time at the removal or disabling of access. It should also provide clear and specific statement of a reason of that decision. And Article 15 also lists what information should be included in that notification. So if it concerns removal or blocking, facts and circumstances leading to that decision, if the decision was made using automated means, legal or contractual grounds, and what are redress possibilities. The provision says that notification should be sent at the latest at the time of the removal or disabling of access, but it doesn't really leave much room to wait for a response to take it into account when making the decision. So these provisions don't really introduce what some were advocating for, like a counter notification mechanism, but rather a complaint through an appeal mechanism. The DSA provides also several safeguards to address concerns on effective remedy for the decisions with regard to removal or blocking of access. And that is good because, you know, these decisions are not easy ones and mistakes may happen. So there should be a way to correct them, to reverse the decisions. So we have here internal appeal mechanism or a complaint handling system in Article 17. And that specifies that the mechanism should be available for at least 6 months following a removal decision. A decision to, so it's removal, it's also decision to suspend or terminate provision of services or to suspend or terminate user account. And that refers to both situations when content was considered illegal, but also incompatible with terms and conditions. The provision does not specify exactly what elements should be included in the complaint, but it does say that if a complaint contains sufficient grounds showing that information is not illegal or incompatible with terms and conditions, it should be reversed without undue delay. So that actually introduces a possibility to reinstate or put back content. And also what's interesting here is that Article 17 talks about complaints in case of removal, blocking, or suspending decisions, but it does not mention a possibility to appeal a decision where initial notice, so under Article 14, was rejected. And that may seem counterintuitive from the perspective of freedom of expression, but it does happen that, for example, notification on online abuse is rejected. And as a result, that leads to chilling effect and suppression of minority voices or underrepresented speakers. There's also out-of-court dispute settlement, which is quite a novel idea here and looks very interesting. But I think actually Martin might be a better person to talk about it. There's also judicial redress that doesn't have its own provision, but it is mentioned on several occasions as one of the redress possibilities of which the user has to be informed. And then we have numerous transparency provisions, and they are applicable depending on which type of intermediary we're talking about. So we have transparency on reporting addressed in Article 13, 23, and 33. Also a database of decisions managed by the European Commission in Article 15. There's also a provision on access to data by vetted researchers, which is something that was long requested for. There's also Article 44 on the activity reports by the Digital Service Coordinator that would have to include information on the numbers of orders against illegal content and orders to provide information, which is in Article 8 and 9. And that looks very promising, the number of provisions on transparency, but I will not be the first one to say that, well, transparency, it has to be meaningful, right? So it also very much depends on how that would be actually operationalized. But yeah, it has to be meaningful to give full picture of a situation that could ensure some accountability. So in general, I consider, DSA definitely a good starting point with considering the number of safeguards. The proposal does not address some of the concerns that were already expressed about the e-commerce directive. So I think there's definitely some room for improvement here. And I have one last slide, maybe of what I would say could constitute risk for freedom of expression. So one thing I wanted to mention is that DSA primarily targets illegal content. It does mention illegal hate speech, for example, as an example. It talks about manifestly illegal content, which is understood as information where it is evident to a layperson without any substantive analysis that the content is illegal. So it could be hate speech, but not necessarily, and these two terms are not equivalent. But the DSA contains several provisions that could extend the scope to content that is not illegal, but is harmful. So sometimes, referred to as extreme or lawful but awful content. And this content could be prohibited through the provider's own private ordering. So we have voluntary own initiative investigations, terms and conditions, risk assessment, codes of conduct, and also crisis protocols, which I think the last ones were introduced specifically with this information on the pandemic in mind. And now I'm not sure how am I doing with time. Miguel, should I continue? I can say some words. Okay, so specifically about Article 6. So it addresses voluntary own initiative investigations aimed at detecting, identifying, and removing or disabling of access to illegal content, but also measures taken to comply with platforms' terms and conditions. So that could include harmful speech if it's prohibited through the terms and conditions. The provision attempts to incentivize hosting providers to take more initiative against these types of content, but without immediate risk of losing immunity, which was the case or the risk under the e-commerce directive, where they could have been considered as active hosts having actual or constructive knowledge. So it furthers policymakers' goal to have intermediaries do more content policing, but without violating the prohibition of general monitoring obligation. But that would most likely lead to more removals of content. Maybe I'll shorten a little bit, but when reading recital 25 of the DSA, you can see that, following this provision and taking voluntary actions, even in good faith, doesn't really guarantee, but also does not preclude neutrality. So the possibility of losing immunity still exists if the taken measures lead to knowledge. So on the one hand, the provision, creates more risk for the effective exercise of the right to freedom of expression by encouraging more voluntary takedowns. But on the other hand, it's not really creating any more predictability for the providers who may want to voluntarily tackle some forms of harmful or extreme speech through their terms and conditions. And I will maybe stop here, but I'm happy to discuss further. Thank you so much.
Thank you so much, Alexandra. Of course, we will have the opportunity in the Q&A and discussion to continue with these different issues. And now we have Gloria González Fuster. Gloria is a researcher professor at the Free University of Brussels at the Faculty of Law and Criminology. She's also co-director of the Law, Science, Technology and Society Research Group there. And overall, she's a leading expert in the field of data protection law. And for one thing, she's the author of a monograph on the recognition of the right of data protection in the Charter of Fundamental Rights of the European Union, and has authored extensively in this field, also touching upon fundamental rights more generally. So thanks very much, Gloria, for accepting to be here, and the floor is yours to deal as you wish.
Thank you very much, and thank you very much for the invitation. I've already learned many things with this panel. I feel a bit like the outsider here. I think these are very, very interesting, exciting moments for data policies in general, and they are interesting moments for data protection law, but we are not really like leading the movement at the moment. We are more like defending a bit. So I think that the instruments that we are discussing now, especially in this panel, because we suggested to have this focus about DSA and DMA, they are not really driven necessarily by data protection concerns, but by other concerns. And data protection lawyers were a bit like trying to see what are the risks and how do we make sure that this is somehow contained, that it's not going to have a negative impact. So I think it's great to have other experts who know much better about the other aspects. In my presentation, what I wanted to discuss, just put on the table what are, I think, some interesting elements of those proposals from my perspective, and yes, and just open then the floor for discussion. So I think basically from a data protection law perspective, when we look at all these developments in general that we have now, there is this basic concern about are those instruments aligned with data protection law, which is what they say they always say they are, that they are aligned with the data protection acquis, that they are without prejudice to the GDPR, and then one always has to double check, is it really true that they are without prejudice to the GDPR? It could be that actually they also do something that is positive for the same concerns that the GDPR has. And I think that's very much the case of the Digital Markets Act, the DMA. And it could be also that they include something, nevertheless, that actually is a risk for data protection, rights to privacy data protection. And that's also, I think, the case with the DSA and with the DMA. So just, I will give some elements about this. There are 2 opinions published by the European Data Protection Supervisor on the 2 proposals. They are excellent opinions. So if anybody has not read them and they want to know more about the data protection issues, of course, I encourage them to read them. There is only one proposal now on the table of this whole package or mega package or series of packages of initiatives in the policies, data policies area, which is really about data protection law, and that is the Artificial Intelligence Act. This is the only one that actually is partially based on Article 16 of the Treaty of the Function of the European Union, which is about data protection law. And it is supposed to develop also this right to data protection in a way that it's quite interesting and funny and paradoxical in a way, because it is only insofar as it is concerned with facial recognition, like remote biometric identification, live facial recognition, that then it will regulate data protection law aspects, and supposedly to give more protection, and I'm not sure it really does. And for this, I was just listening to Martin, this great remark that indeed the European Union legislators should know now that they cannot just produce proposals that do not include safeguards. So they foresee an interference with fundamental rights, but they outsource, as Martin said, the safeguards, and they postpone them for later. Like, member states can just do this, and they will come up with the safeguards, and we know that it's not the best approach, and we know it with Digital Rights Act, and this is exactly what is happening with this Artificial Intelligence Act, and I think it is quite problematic, and perhaps this will be solved, but we will see. So this is basically, they are saying, we prohibit this, but you can do it, and then you will put the safeguards by yourselves, which really doesn't make a lot of sense. So I have a few remarks about the DSA and about the DMA from my very subjective perspective. So the DMA, I will discuss this briefly before, because I think indeed it is very much concerned with a major concern of data protection of the GDPR, and this is this question of fairness and contestability of those platforms, of those big players that we have. And I think it's important to keep in mind, and it's said somewhere in the memorandum, that data is such an important asset of those platforms, and indeed they are very much, they have been growing thanks to the processing of data. And I would like to add that de facto, in practice, they have also grown to the beasts, to the giants, to the monsters that they are, because of systematic violations or disregard or avoidance of data protection law. So they have, for many years, tried to argue that European data protection law did not apply to them. Eventually, we had the GDPR to make clear that it applies to them. Then they come up with their own interpretations, and it's a continuous fight from a data protection law perspective to keep those monsters somehow under control. So it is good that there is something else on the table that also aims at making those companies contestable, fair somehow. So that is good for data protection. Now, it doesn't mean that everything in this proposal is perfect from a data protection perspective. So a couple of remarks about this question of alignment, which I really think it's one of the most interesting issues that we are working on in the field of data protection law. It is this question of how does data protection law intersect with other instruments, and it is quite complex, and sometimes the complexities are really coming from just the fact that other instruments will use the same words that we use. How can they dare to do this? We should have a copyright on all the terms that we use, so they don't do this, but every time they do this in a sort of ambiguous way, we run into trouble. So there was the Payment Services Directive, the second one, which said people have to consent to the use of their data. Then we are still struggling somehow to understand really, is this consent our consent? Are they saying the same? How do we make sure that this makes sense? There is also this, for instance, the regulation on the free flow of non-personal data, which says we will not say what is non-personal data, it's what is not personal data. but then it's not completely clear. So the Commission published some guidance, but then it's still not completely clear. So we have already to devote a lot of attention to this question of the alignment, of the intersections, and I think this will become even more interesting in the future. So in this opinion that I mentioned of the EDPS, there are already some concerns about this. How do we make sure that they are using our words correctly, or that they make clear that they are using them differently? There is one term that it's not discussed there, and for me it is really one of the key terms that I think it is potentially a problem, and that's the definition of data itself. And this can be a problem because we know that what is missing now in the pipeline of proposals is this data act. So there will be an act that will regulate other issues about data. So they will have to define data. And now we have a proposed definition of data in this DMA and a proposed definition of data in the Data Governance Act. And this definition says something like data is any digital representation of whatever, of acts, facts, whatever. The way we in data protection law define personal data is not any digital information, but it is any information. So personal data is any information, but data is only digital information. So it means that there is some personal data which is not data. And for me, this is a conceptual thing that I don't understand it, and I don't know how can people understand it. And it would be nice that we address this paradox before we just, yes, there is something that we collapse because of this paradox. So this is one thing that I have with this proposal. And then the other thing that could be maybe look minor to you, but it's important for me, it is the question of data portability. So I'm personally very interested in data subject rights in data protection law. Can people use their rights for real, yes or no? And there is this right of data portability, which is somehow not the favorite of data protection law scholars, because we think it's not even, we didn't invent it, we know it, comes from somehow from competition law. So we don't like it that much. I think competition lawyers don't like it, also the fact that we stole it. So nobody really takes this right seriously. We don't know that much. We know that it doesn't work, and still it pops up in proposals. So it pops up in the Data Governance Act, like there will be a support for data intermediaries helping to have this data portability, and it pops up here in the DMA now, pretending that we will have one day a right to data portability real time, that we can access our data real time and have this data ported real time. So this right to data portability, as it is in the GDPR, it is in the GDPR. People got very excited when they put it there, some people, and it doesn't work. I have to tell to everybody, it doesn't work. I would love this right to work. I love data subject rights. I love to use them, but it doesn't work. And I'm also very contradicted myself, because I would like to tell people, please, if you think it works, try it, and you will see it doesn't work, because I think that's a reality check that we should all do. The people who really write this idea that data portability will be function real time, they should try once in their life to get some data portability from Spotify. And I would like to tell them this, but because I'm a nice person, I don't actually recommend everybody to use their data portability, to try to do it, because it causes a lot of pain. It is now painful in Europe to try to exercise the right to data portability. I have tried. With Spotify, it caused me many emails, many misunderstandings. They say, here's your data, and say, I don't want my data access request. I want to exercise portability. At some point, after many emails, this escalates. They say, well, if you wanted to port your data directly, this is not going to happen. Say, okay, I don't know anymore what I want. This is one example. In another case, I tried to exercise my right to data portability, and actually my account was deleted. My purchases were cancelled, and I lost everything, and then I had to insist, so they apologized, and I recovered something of things that I had bought that were copyrighted, and I have bought them, but my account was deleted because I exercised data portability. So it's a catastrophic situation, and they say, great, the data portability, let's go further with this. So you plant a seed, there is nothing growing, but then you already think you have a forest of things, and that's, I think, a problem. So I don't think it's like by multiplying these attempts to have data portability that it will work. But that was mainly my criticism of the DMA. And I wanted to say something about the DSA. And what I wanted to say, basically the question of the alignment also issues there. I think the word that they use without proper care is liability. So that's one of the concerns of the EDPS. Are they using liability in the way we use liability? So we know they are not. So they the suggestion of the DPS is please write it down. We know there are many indeed questions with all this procedure that Alexandra was describing about content moderation, which data are used, can they do this in a proportionate way? There are many, many issues. But I think the most interesting debate here now from the perspective of data protection law is really the question of online targeted advertising. And that's what the most interesting reaction probably from the European Data Protection Supervisor was this question of, yes, this goes in the direction of having more transparency, the transparency that Alexandra was describing about how we are targeted online when there are ads. Also, we have more transparency about when there are, we receive some content because there's a recommendation system, but especially with targeted advertising, the EDPS said, at some point, we should just get rid of this system where there is a pervasive tracking of users in order to give them ads. And I was kind of smiling with Alexandra's picture of the meat, because it reminded me, like, I think it was on Monday, I was on a train and there was this football match with Spain, and I thought, I want to know the result. So I checked with my phone, is Spain winning or whatever. 1 second later, I have this ad, you are a Spanish expat in Belgium, you want to buy ham. And there's a little pig, all of ham like this. My problem is I'm vegetarian. So if you put me in my phone pictures of ham and little pigs, I think it's offensive. Like I thought the picture of Alexandra was this gatekeeper showing me this meat, it's offensive. So how can I say, please stop, leave me alone or show me something else? You know that you should know I'm vegetarian, they should know it, but no. So is this DSA thing going to solve my problem? Not really, because what could happen is that there will be a repository where a few months later I will discover that I received this stupid ad because they thought I was interested. But can I really react with this? I don't think I can really react in real time to this. There are some provisions that actually say, yes, you should be given an option. You should have the right to know. Again, I will have loved somebody to be sitting on the seat of the data subject for 5 minutes and see how is this going to work in practice, because I'm not sure in practice, knowing what we know about how difficult it is now when we read data protection notices to just know when there is some profiling going on. You will never know. When it's some automated decision making, very rarely you will know. So do we really believe that the terms and conditions will explain exactly what is happening? Unless we really are much more serious about this, I don't know. I don't know how my right of access will work with that constructively. So I have many questions about this. Just the final message about this online targeted advertising and the message from the EDPS was actually that all these kind of targeting people pervasively on the basis of this constant collection of data and profiling, that it should phase out. It should be phased out with the hope, in line of eventually making it disappear. So that eventually we should have a system where we are not all submitted to this pervasive tracking. I think it's an interesting perspective, especially that now the Norwegian Consumer Council has just published a report and a call which is more or less the same but the opposite, saying we should try to ban this pervasive surveillance-based advertising, so eventually it will phase out. So it depends on how optimistic you are and how you believe that you first ban something and eventually it will disappear, or you try to hope it will disappear so you eventually ban it. But there is a massive problem. I hope that the debate eventually will lead to something with this DSA or another instrument that will take us somewhere with this. But with this, I would just stop now. Thank you.
Thank you very much, Gloria. So we will now start the debate. We have some time for it, at least for half an hour or maybe more. So I would like to thank Pedro Hinojo, who is joining us for this debate. Pedro is a member of the Comisión de los Mercados y de la Competencia, the Spanish Authority for Market and Competition, and he has provided a keynote speech which is available on the website of this conference. And we would like also to engage with him in the discussion of these issues, particularly from the point of view of the GMA. Well, listening all your interventions. I'm a bit overwhelmed by uncertainty, by the difficult to foresee the future in this area. So I've heard of data which is not data. And I could think about general monitoring, which is no general monitoring. I could think also of communication to the public, which is not really communication to the public, as we knew that, or neutrality as a threshold requirement for the safe harbor, which is not exactly that neutrality. So a lot of uncertainty and some difficulties to clear up this field. So I would like to start by asking the panelists. Most of the discussion deals with the duties of care of platforms, whether ex ante or ex post. And what do you think? Where do we stand regarding the ban on general monitoring obligations? You know that the Court of Justice has somehow shifted to a more permissible interpretation of monitoring, which would be outside the scope of the ban, particularly on the Glosnik case and Facebook. So, do you think this approach that essentially would allow to require platforms to dig somehow into their contents to find illicit content is a trend that will prevail in case law, and will it expand beyond the field of defamation to go also into the field of some other fields like particularly copyright? Any of you who wish to say something about that?
Alexander, would you like to say maybe first something about general monitoring? I can then say something about copyright specifically.
Yeah, so thank you. I think this is an excellent question, and to be honest, a very worrying one. Another issue to worry. Indeed, the e-commerce directive had this prohibition of introducing general monitoring obligation by states. At the same time, I think it's also worth remembering that it does not actually prohibit general monitoring by platforms if they want to do it on their own. And I think, because of that prohibition, that was sort of a way to introduce monitoring was by voluntary measures and encouraging platforms to engage in voluntary monitoring. We had that in I think, communication on combating illegal content a while ago. But what happens at the same time is that we have all these sectorial instruments, right? So on copyright, but also on terrorist content, preventing dissemination of terrorist content online, but also the self-regulation or the co-regulation on combating disinformation, the code of practice on hate speech. And there are, let's say, the e-commerce directive has a horizontal approach, and the DSA reproduces it. But at the same time, we have now all these specific instruments, which actually, in a way, do introduce certain obligations to monitor or encourage voluntary monitoring. So I think it is very much, this is something that I would definitely worry about, that, it is still there, it is repeated in the DSA, but I think there is a strong risk that it will become rather meaningful, because we will be looking at monitoring, for example, for terrorist content. Also, what the Glavišnik-Piszczek did, for defamatory content, it said, okay, it's not only for you have to prevent re-upload of exactly the same comment, defamatory comment, but also equivalent comment. And okay, that would not, it's not in content that would require any additional analysis. But, it is broadening the scope of what has to be monitored. And also, it's not only from the same user, but also from other users. And that was, I think, a surprise for a lot of people, that this ruling does not actually mention the previous rulings on Article 15. And it's definitely going farther. So I think it is opening the door for more monitoring introduced. In terms of how that would work with the copyright, Martin, I leave that to you, because for me, to be honest, it is still not entirely clear how Article 17 would work with Article 15 of the e-commerce directive, or whatever Article, I think 7 now in the DSA.
Yeah, so I mean, that's obviously an open question. No one knows. I think the reference to general monitoring in Article 17 specifically, I mean, there's a nice article by Martin Zinflip and Christina Angelopoulos on this, who are trying to make sense of this. I guess I'm converging to the view that, probably to the view that actually Commission takes in the guidance, which is basically, yes, it is the same concept, but probably means something slightly different in the context of Article 17. I guess that's the only way how you can reconcile this. In terms of what it means and how Glavišnik-Pieszczek actually influences the scope of injunctions and what Peterson case has to say about this, so my reading so far is, I don't necessarily see that a Peterson case would somehow influence the scope of injunctions. I don't think that is somehow even implicitly there. German court didn't ask about a scope, only asked about the precondition of issuing a notice. There's this big question mark to what extent Glavišnik-Pieszczek should be also read as permitting something broader in the realm of copyright injunctions. I don't know. I think there are different arguments that you can make. You can make an argument that the Glavišnik-Pieszczek is about a judicially determined infringement of personality rights, where the scope is delimited by the court, and then the equivalent content, quote unquote, is actually not in essence change content, so it's actually much more marginal. Now, would that mean that in a situation where there's no judicial determination, the same kind of preventive standard applies? I don't know. I don't think so. On the other hand, you can say defamation is much more difficult, much more contextual. So copyright law could have more permissive standard. Honestly, I'm not going to try to sort of guess from a crystal ball. I don't have one, so it's hard. I don't know. I guess what is more important is, what is the point of that obligation? And then in my mind, the point was always actually to prevent that you impose too onerous obligations on the platforms that could perhaps inhibit the freedom of expression of users. And also of the platforms, the fact that the Court of Justice doesn't conceptualize their interest as freedom of expression, but as a right to conduct business is just, I don't know, it's just the Court of Justice. If you look at ACHR, it's not the way the ACHR looks at it. So the answer is, I don't know, Miguel.
That's always a good answer. So,
Miguel, can I add
sure.
some quick? Yes, most as you have rightly pointed out, I work in competition, so I'm mostly focusing on the DMA. But I wanted just to say some quick words on the DSA, because also my institution, the CMC, also issued a position paper on the DSA. So they and this partly relates to your question. So the CMC also acknowledged that it was necessary to update the framework of responsibility of platforms to update the e-commerce directive, but it is really difficult to strike a balance between protecting users on consumers from illegal content or harmful content, but also to guarantee the free flow of ideas and opinion and information. It's really, Martin said, sometimes it's very difficult to find really a solution to all these issues, because also protecting freedom of expression and flow information also includes fighting against disinformation. So this is really difficult. In any case, we shared a statement in favor of an asymmetric framework. We think that not all the platforms have the same responsibility or the same means to combat some of these threats. And we also mentioned that perhaps the framework should be updated in the sense of including more exceptions to the country of origin principle, to avoid the issues of forum shopping and all other problems that can arise, and perhaps include also a more European mechanism to address differences or conflicts between national jurisdictions. So that was all what I was going to say about the DSA. Thank you.
Thank you very much, Pedro. Precisely, I wanted also to consider some of the issues from the point of view of the business models. So all this new regulation, including both the liability and the scope and the limitations of the scope of the exemptions of liability, and also the competition rules will affect the deployment or the development of these platforms. They are to a large extent based on the exploitation of personal data. So will this, on the other hand, the new rules somehow may be easier for the incumbent companies to comply with than for the newcomers? So this is some sort of a paradox that when we are trying to rein or to establish new requirements, this will in fact benefit the already big players and make it more difficult for the newcomers to prevail. So from the point of view of the market, of the development of these business models, I was thinking, will the improvement of data protection rights and the actual achievement of a more intense protection, so that, for instance, in the field of personalized advertising and some other fields of profiling and so on, if this is really going to be established and prevail, will the established business models be able to stand? So this would entail the need to change some fundamentals of the working of these business models, and more from the point of view of competition. How do you see, Pedro, that the newcomers will be somehow deterred or put in more difficulties once we go into this new regulation. Of course, there are obligations which are also meant for big players, but still there are a lot of them that may be really hard to comply with by the small ones.
Thank you, Mikel. Good question. I start and then I leave the floor to the rest. The advantage of the DMA is that it is asymmetric per se. It's only targeting the gatekeepers, and we think it's a good approach to deal with this issue. GDPR was horizontal, and it has actually affected competition, and actually it has directed more traffic to gatekeepers, because for instance, we only accept the terms and conditions the first times we log in, and then we don't have to click a consent every time we use Facebook or Google, or every time we are logging in Gmail. So they capture a lot of data, the first party data, high quality data to sell targeted advertising. So we think that a more asymmetric approach is perhaps needed, especially if we are consider these principles of portability, which, as Gloria has said, perhaps is not going to work. But now, at least it's only affected in theory, or it's only on the big platforms to ensure this principle for business users and also for final users. So we think that in order to avoid extra burdens for small players, as you have said, a more asymmetric approach is more advisable, and in that regard, the DMA could be the right tool to address these issues.
Gloria?
So to your question, are we going to see some fundamental change? Hopefully, yes. I think that's the whole purpose of this, that some fundamental change has to happen, especially I think in this trend to just build big companies that are connected to other companies that are connected to other companies that have those big services that are all interconnected, into which we are connected. I think that's at least one of the practices that should be somehow stopped, that we are indeed not naturally absorbed in this mega network of things that are communicating data about us. That is one of the purposes, and I think that the question of the asymmetric, not symmetric, horizontal, it's interesting indeed, because we do have those different instruments that somehow have to be aligned. They pursue similar objectives. They all have to comply with the charter, but indeed some of them will target some companies. The GDPR is not asymmetric. It is very symmetric. The idea is that it is on purpose that everybody has to comply with data protection obligations, because it doesn't matter if it's a big company violating your rights or a small company. It doesn't matter if you die because you're intoxicated by McDonald's or by the small shop in your street. You don't want to die. You don't want to have your fundamental rights violated. So that is the perspective of the GDPR. It covers everything. Then indeed we have special rules for the big players, special rules for the small players, and those rules covering everything have to be compatible and meaningful from a data subject perspective in all scenarios. And that is probably something indeed that also deserves more attention. Is it really then meaningful? Is it useful? It has to be a question, but I hope that indeed all this leads to some change. I think that will be the ideal scenario.
Miguel, can I just very quickly comment on this?
Of course.
Yeah, so what I want to say is that actually two things. So actually, if you look at the DSA, and you look at the threshold in terms of the size of the companies that are the target, very, very few obligations and very benign, not so far-reaching obligations actually attached to companies below 50 employees. If you really look at those obligations, it strikes me, and because I've been just recently participating in a panel where someone from Slovak ministries was sort of voicing this concern. So I said, okay, just have a look at that. And when we look at the thresholds, because you have exemption for micro and small, and you have that exemption there, and and of course the most of the obligations go for very large online platforms. It actually turns out that not that many obligations are directly imposed on very small companies. Now, what I think is a bigger issue than perhaps regulating is, and of course, there's always risk of uncertainty, right? I mean, there's something new, there's uncertainty. But I think even bigger problem than uncertainty is uncertainty to the power of 27, meaning fragmentation. And this is something that we have a fantastic case study in copyright law, where Article 17 is just going to be that. It's just going to be a disaster case study in how you can actually fragment the digital single market even more than before you actually initiated the harmonization. So I think perhaps what I'm personally more worried about than whether there's some uncertainty, because there's always some uncertainty, is that you multiply the uncertainty by introducing too many derogations that can be introduced on the national level, which will just fragment the solutions even more. And I prefer to have uncertainty that is uncertainty on the European level that you can still clarify through the dialogue. And yes, it can be messy. Communication to the public case law, fantastic case study in that. But look at that. The court is actually developing something meaningful, I would argue. It's not that what the court is doing is completely without purpose. I think it's actually stepping in place or stepping into the shoes of the legislature, what the legislature should have done. And yes, it's messy on the way, but I think it kind of works. And data protection law has also these sort of stories, I think, to tell. So I would be more afraid about fragmentation, like what happened in the Article 17 and will happen in the Article 17 realm if it survives.
Thanks, Martin. If it survives, that's a great question. Well, I think one thing we have learned from the YouTube Peterson or Siando case is that the court has, at least to me, I mean, I don't know if you agree, has clarified that that Article 17 is not a clarification of, as it was purported in the recitals, a clarification of the communication to the public right as it stands in the InfoSoc directive. So this is well, as you, Martin, and Joe Pedro Quintais and many others have put forward, this should be regarded as an ad hoc or sui generis right. So do you think this will have real consequences in terms of enforcement and of interpretation of this right, or in terms of allowing new exceptions in case Article 17 is going to survive to the challenge by Poland?
Yeah, well, it depends on what the court will do. So in case they wouldn't invalidate Article 17, they probably would provide some interpretation, and that would probably already complement what is in the law. But yes, I think the fact that it's clear that Article 17 is an extra given to the right holders, given the baseline in the Article 3 of the InfoSoc directive, it's clear that the member states can do much more with it, right? Because it's not constrained by the InfoSoc framework. Now, I always say that at the same time, because these platforms are exploiting works along with the users, the actual maneuvering space is limited by the fact that exploitation acts of users are still called by the InfoSoc directive. So without going too technical here, the point is that you still remain indirectly limited by the InfoSoc directive, but basically the provision that I think will open the most doors is the fact that whatever licensing there is for Article 17 can extend the license to non-commercial uses to users, and I think this is where the contentious part is, where German solution is, which German solution is using as a basis, and then it's much more open. But I think in general, I think the fact that you realize that this is extra and this is going beyond the existing framework already means that the member states can do much more with this provision that some people would like to see. And it's a directive. So ultimately, I think it's going to happen that there will be many different implementations, and this is only strengthening that trend. So from that perspective, I think it's going to increase the experimentation on the national level.
Thank you. Please do feel free to throw each other questions. So maybe Pedro, you want to intervene or to ask clarifications from our panelists, or to give your point of view more from the competition perspective, or whatever. I have a list of questions that I would.
If I may, I can just say a few words, perhaps especially from an economist point of view regarding the phenomenon of targeted advertising. Targeted advertising has been like is a tremendous disruptive innovation. We have seen that digitization has done two things. It has created new sectors. I don't know, e-commerce as such is a new sector. Search engines, social networking services, they didn't exist. Advertising already existed, and it existed, but it is new since we can target advertising. Advertising is no longer contextual, as is when of course there were TV audiences. There was some segmentation, but it was not a perfect segmentation as we can do now with targeted advertising. Targeted advertising exists because it's tremendously valuable for advertisers. So this is something that we have to be aware of. Of course, if there are some restrictions to the way that targeted advertising exists, or to the way advertising is sold, this is going to have an impact on advertising and on the economy, and perhaps especially on smaller firms who need the most advertising to convey new products or new messages. We have to be aware of that. There are no movements, and we have to be very, very, very careful. So with the movements that some market players are acting, because now, for instance, Google has announced the ban of third-party cookies in Chrome. Apple and also Android are saying that they are going to raise more, or they are going to be to restrict, to be more restrictive on how, for instance, apps accumulate data and track users when they opt out of the system. But with those movements, of course, targeted advertising does not disappear. Does not disappear. It just changes who is selling targeted advertising, and if ecosystems like Apple and like Google always keep their ability to sell targeted advertising, because they accumulate a lot of data when we navigate through their properties. So this is a new phenomenon. Advertising and contextual advertising is of course not so valuable for advertising. We have to be aware of that. It is true that I think that consumers are becoming increasingly aware of their privacy. I think that perhaps this is a little bit this is changing, because we have. It is true that there are some studies that point out that consumers are less willing to pay for content on the internet. So they are very price elastic. So if they are going to be charged, they then go to a different property. But at the same time, it's true that more studies, and it's also true that consumers, they are very subject to, or they are very vulnerable to short-term gratification, that they value defaults, they value the convenience of ecosystems that integrate all together. But at the same time, it's true that now there is an increasing amount of consumers that feel that targeted advertising is becoming increasingly intrusive. So they say, look, this is too personalized. yes, it's more relevant, because the problem what Gloria was mentioning of the mid advertising, that it is a problem of bad advertising, because if advertising was more personalized, it would have been better for her. So it is not so it is true that when advertising is too intrusive, it is too targeted. Perhaps there are some consumers that are going to consider that too intrusive, or that they prefer. But it is very difficult to change this market dynamics, because target advertising, especially when they use data of location, is much more valuable. This is just, I was just describing the market dynamics. I was not taking any particular stance on this topic.
Perhaps if I can react. So I mentioned this report by the Norwegian Council of Consumers, and precisely they discussed this point. Is it really more valuable? It is not that clear. There are also examples in the other way that say that actually contextual advertising can be in some context more valuable. So I think it's important to insist that yes, it can be very useful for some actors to make more money. It is very, very problematic from a fundamental rights perspective, the way in which it has developed. And what we see is that from a data protection law perspective, it is very difficult to stop it. So indeed, some kind of reaction is necessary. This is why the EDPS is calling for this phase out, so initiatives, new things to shake the system, because as it is, we know it is beyond control, in the sense that, so for me, the problem with consumers being concerned is not a problem. So if consumers are aware that this is pervasive, that they are being targeted, I don't even care that much for them. I don't suffer for them, because they are aware that they are receiving this. I'm very much more concerned with those who don't see it, with the children who are submitted to those practices. Those are vulnerable people are also just suffering all this very, very pervasive tracking for advertising purposes, for some companies making money. And how do we protect them if we don't stop the system? We cannot just put some instruments there so they can opt out, maybe perhaps when they realize they are being manipulated, it will be too late. So some systematic solution, some important, bigger solution is necessary at some point to protect those who really cannot just protect themselves by having the data protected, if they ever manage before they grow old to protect the data. So I think the system is really somehow now rotten at some level, and I think that there have been attempts from NGOs to litigate about this, to try to make to have some clarity. I think data protection authorities are clearly not in a position, for many reasons, to solve this problem by themselves. This is why there are calls for different solutions. And I'm afraid that the argument of saying, well, it's important for the money, it is at some point, it is a valuable argument, but not strong enough when you see that the risks, some risks are so significant.
Thank you.
If I could maybe add something.
Sure.
Also because I have to leave in a moment.
Yes, I know that.
So,
thank you.
So it kind of sounds like, you know, if Gloria, if you were profiled better, then they wouldn't have showed you this, because they would have known that you're vegetarian. And by the way, I'm sorry for putting on that meat picture in your face. I will remember it for the next time. So I just wanted to add here, and also, like, you know, referring back to the question on business models, that the issue with using personal data for targeted advertising, you know, we also now have this issue of using the same or a similar style and profiling people to address and direct other content at them, right? So, and that leading to the spread of disinformation and possibly trying and sometimes successfully to influence their life choices, their political choices, choices that they make with regard to their health. And I think especially with a pandemic, that is also visible. So I very much agree and support you know, the call of the EDPS. And I think indeed, especially for if we want to seriously do something with disinformation, that is definitely also you know, a way to address it. And the problem with addressing disinformation, I mean, it's sort of there, not directly in the DSA, but it comes back in different provisions. And the difficulty is that we have different provisions, different laws on illegal content, but many times when we look at disinformation, it is not actually illegal content. So then why should a state, act against it? Why should a state prohibit it or, request removal? On what basis? And so we have to remember when you look at the jurisprudence of the Court of Human Rights, that content that is offensive and controversial and shocking is still protected, that type of speech. And of course, there are limits. And when we talk about hate speech or defamatory content, it changes. But a lot of times this content is still protected. So then why are we asking intermediaries to remove it? And obviously, it is such a difficult situation to find a balance to, of course, still protect people who are then making being misled and make possibly stupid or even dangerous choices on this basis. So I think that, we're not going to be able to solve every issue, because I think that's also, it's worth remembering that, a while ago we talked about the filter bubbles that you fall in and you're being targeted. And I think right now it's becoming clear that for many people, it is more of a conscious choice, that it's not something that they are not aware that there are not that other points of views don't exist, that they are aware, they just kind of choose to stay in whatever bubble they found for themselves, being reinforced in their beliefs. But I think, also in terms of how people are targeted with disinformation on Facebook, for example, that is very much the similar underlying problem of personal data used to then address people knowing what triggers them, what's going to possibly make them upset, to make them then, of course, keep them engaged on the social network platform, which is obviously good for the social media, for the platform. So I think that, basically, I definitely agree that, it's not only for targeted advertising, but also, and possibly even more of an issue for disinformation, and in the DSA that's addressed in the provision on recommender system. But yeah, the mechanism behind it is the same. And I think I have to leave. So thank you very much for this. I will watch the rest of it online. Thank you very much again for inviting me and for the great discussion.
Thanks to you, Alexandra. Thank you very, very much. So we'll keep in touch and follow the discussion through the internet.
Thank you. Bye-bye.
Right. So we still have some room for discussion. I have some questions from the audience. As though, well, they are somehow interrelated, so I will just put them all together, and feel free to deal with them as you see fit. So one question relates more, I'm not sure if I understand it very well, but a user called Pingale says, what do you think about active researchers of crimes that affect freedom of expression by the police or other agencies? Is that something necessary? I think this relates to different, well, uses or intrusive activities regarding data protection and fundamental rights. But also we have a different kind of question more related to competition, which is from Professor Chalaverde, which is, that would be for Pedro and for Martin. What do you foresee will be the effects of Article 17 of the Digital Single Market Directive, so these new liability rules for big platforms regarding copyright infringement. The effects of Article 17 in terms of competition among different platforms, also taking into account the somehow different duties which are imposed in different kinds of platforms, also in the DSM directive, and also a more data protection question that from Professor Monica Vilasao, who says regarding the business models, and particularly target advertising, shouldn't we face the fact that we are paying with our data and then apply contract law to deal with that? So I'm dropping these questions on the table so that you feel free to say what you want about it. Who starts?
Martin, I think Martin has been silent for longer.
Okay.
Go ahead. Yeah, so impact of Article 17 on the market. Frankly, I don't know. It depends on what is the licensing solution on the national level, I think. But I guess either way, the one trajectory that there is that it's just more expensive to be an OCCSP than it is to be a regular hosting provider, because you need to pay licenses. Now that's the objective of the directive. So that's, you know, not necessarily bad thing. We want, or perhaps the European Commission decided to have a redistribution within the industrial policy that decided to do it this way. Okay. So I expect that will also mean that there are changes for the business models under which these OCCSPs operate. So in case you are OCCSP and you need to engage in direct licensing of content, whether that's through individual deals or extended collective licensing or something else, that means it's more expensive than advertising based licensing. And that obviously means that you need to earn that money from the platform differently. So what I would probably expect is, if you are OCCSP and you already have to pay for a license anyway, then you engage in much more integration of the content. So perhaps what you wouldn't do before because you were afraid of becoming too active, now it's of no use anymore to shy away from just integrating content into your own offering as if it was your own. And that obviously means that you actually become something much more different than just a platform for other people's content, but you actually become a platform of content that was provided by other people, but somehow integrated and maybe even rehashed by you. So I guess that's something I would expect. And I would expect that you put a different business model probably on top, assuming that advertising is not sufficient to sustain this, especially on the smaller platforms. Yeah, so I would expect different business models being applied by smaller players if they're OCCSPs, and when they're bigger players, maybe they can sustain it by advertising. So maybe YouTube can, I don't know. I don't see their financials, but yeah, that would be my expectation, how they react to this.
Pedro, maybe you want to add something?
Yes, starting with the last issue you mentioned on target advertising, are we paying with our data? Of course we are. It's a variable of the service, and we receive free content because we pay also with our time of attention. We receive ad impacts, and we pay with our data. Data is really the difference between the digital advertising, online advertising, and the advertising we knew before before the digital advertising, there was also the debate of either I pay with money or either I receive a free product, but I receive a lot of ads. So these were the two ways to pay. Now we have data. And data is what fuels like the quality of the advertising from the point of view of the advertiser, the relevance, the how it is targeted. And data also allows the platform to improve its service, because with more data it can improve it can improve recommendations, it can improve personalization of services other than advertising. So that's why there is the incentive for platforms to rely on these models so intensive in data accumulation, because really intensive, and data has become the key variable of competitiveness of digital business model. So yes, we pay with data, and platforms are very happy that we provide them with all this data. And I wanted also to mention a little bit on the debate between ex ante and ex post tools in competition and versus regulation. So yes, competition, except for merger control, is ex post. So we go there once the damage has been done, and perhaps yes, that can be a problem in digital markets. We change so fast. Perhaps sometimes competition policy arrives too late. The perspective of the DMA is the opposite, going ex ante, prohibited some or mandated some conducts ex ante, so that they are automatically executed, these conducts, and automatically enforced. So this always the ex ante tools have the cost, yes, of perhaps being too rigid sometimes, or perhaps not adapting to a case by case. So it's a very difficult dilemma. But with digital markets, it is of course very controversial in competition. But I think most authorities are advocating for this ex ante regulation, or even ex ante competition tools, as some authorities like the German Competition Authority have adopted, like modifying competition law, but included more ex ante tools. So this is somehow a debate so far, and it's tilting towards the ex ante framework.
Gloria?
Yes, I will react also to Monica's question and say hello to Monica. So are we paying with our data? I think that the problem with this question from a data protection perspective, there are three problems. Problem one, it is conceptually inaccurate. It's conceptually problematic to say that we give our data because we keep always our rights on this data. The second problem is, I think, as a metaphor, it is the wrong metaphor, because when we try to apply this like visually, imagine a supermarket. When I go to the supermarket, I enter the supermarket, I put stuff in my car, and then I give some money depending on what I bought. The equivalent to what happens online would be that I go to the supermarket, somebody goes into my pocket, takes a random amount of money that I'm not aware of, they take the money, and then they throw some stuff at me randomly that I didn't ask for. And that's a transaction. This is paying with my data. I think if it's a transaction, it's more like being stolen, being, I don't know, raped, it is not a fair transaction. Now, if we go into this direction, can contract law save us here? Perhaps, but then we really need strong consumer law that help us, because it's not a fair exchange. We will need some rules about consumer law protection for this new consumer. So let's just use data protection law, which are these types of rules that we have to protect the people who are in the unbalanced situation. We have data protection law, and if we take this path that we are just giving away our data, we are actually just diminishing the level of protection.
Thank you very much. We should wrap up. Maybe, well, as I said, I have a long list of questions, maybe more going into the detail of the DSA and the new rules on liability, which are expected from it. But I think it's almost time to finish here. I don't know if you have any final comments on the issues we have been discussing. Well, maybe one of the, just to throw it very briefly, but one of the issues from this YouTube Peterson case is the upholding of the neutrality principle as a threshold to fall under the scope of the safe harbor. So you still need to be neutral, passive, and automatic to carry out an automatic activity. But this again is founded in recital 42nd of the e-commerce directive, which is completely flawed assumption from my view. And but then we have this also Good Samaritan, sort of Good Samaritan provision, which is introduced in the DSA, and also this clarification in the YouTube Peterson case that implementing recognition technologies has nothing to do with not being neutral and having knowledge, which is also somehow contradictory. I don't know if you have any view on how the whole system of safe harbor of exemptions from liability for these platforms will play out, and particularly if you want just a last mention on data protection, there has been traditionally some uncertainty as to the scope of the e-commerce directive safe harbors when it comes to data protection type of infringements. And I would say that this uncertainty is going to continue to be there even if the DSA is adopted, and maybe just in, well, to make it brief, maybe if you are considered to be a controller, there's no way that you have any resort to the exemptions from liability, particularly to the hosting exemptions. Well, those are some this is some food for thought that I would like also to put on the table. But as I said, we are on the last minute, so if you have any comment on this or other issues, please have your final words, and we will close the session. Thank you very much.
So I can quickly react to the YouTube Peterson case. Well, I think the court is consistent. I mean, you can say it's wrong, but we know that. But I think they are smart because you know that Advocate General's I think it was Jaskinen back in Law on eBay criticized this use of the recital, and what did they do? They switched to the argument that it's because of the name of the rubric, which is called intermediary services, that they have to be passive. So they said it's not because of the recital that doesn't apply to hosting, but it's because of the name of the rubric. And the YouTube Peterson says exactly the same. So now it's Grand Chamber saying the same. So I think that's the established law. I think that's the way it is. On the other hand, I think they clarify a number of points on this neutrality criterion in a way that I think were established case law, but disputed nevertheless, including what you mentioned, the Good Samaritan sort of scenario and others. Now, I think generally, it seems to me that what they are doing, and maybe this is also answer what will happen in cases with data protection background, is that they are trying to synchronize the other piece of EU legislation that is reaching the intermediary and the safe harbor. So in the case of Peterson, it was obviously the hosting safe harbor and the communication to the public plus. And I think if you look at the judgment, the court is quite explicitly say that there's never going to be a situation where you have a hosting safe harbor because you are passive/neutral and you would somehow be implicated in the communication to the public. It's just not going to happen because the test for being passive versus neutral is just so in sync with the new criteria for communication to the public that if there is any gap between the two, you will have a hard time finding it, because the court says even the cases where you just didn't react to notification could become a communication to the public. And I think this is basically what can happen also if there's ever a direct challenge to, someone claiming to be a host that wants to get exemption from the data protection principles, which I really doubt that this would ever fly, because obviously the complicated relationship, which Miguel, you're an expert on. But even if you take these data protection cases, right, Wirtschaftsakademie and similar, where you have people that possibly could be in a position, I think the real question is, would they really be in a position of a passive host in that situation? And I think that's the question that a court sort of, I doubt that they would ever say that there is a conflict between the rules. They would find a way how to synchronize the two. Or they would say data protection rules are totally running in parallel, which seems to be now the way this is interpreted, at least implicitly. Maybe they would do that rather, saying this is outside of the scope. So I don't know. My quick thoughts on this, not data protection expert here.
Any thoughts on this, or to finalize, Gloria or Pedro?
I just think that the last question was phrased in a way that was very convincing. So I would just be tempted to say I agree with your reading, and indeed I also agree with the final thought that I think in relation to this, it is very much. I don't think the developments that would affect the reading from a data protection perspective, which now it tends to be built as this. More autonomous, different reading from this perspective. So there might be other places where the frictions are newer and more complicated, but I think that there perhaps we are going towards clarity. Perhaps.
Thanks.
So just to wrap up, actually, I'm going to talk again about data protection, but from the competition perspective. So I think that perhaps. Because there is a lot of talk of the interplay between competition and data protection, there are synergies, other conflicts. I think that it depends. It depends actually on the case, and we competition agencies have not any mandate to enforce the data protection or to look for better data protection, because we are not legitimate and not legally mandated to do that. But it's true that there are interplays, and for instance, what Gloria mentioned at the beginning, when you see, hey, okay, so perhaps that the portability or interoperability are going to be good from a competition perspective, but how is it going to be done? Then we need the help of the data protection experts. So I think that there are ways of like ensuring that everything is more consistent for the sake of the two goals at the same time, when both goals perhaps can be reached. And also there is other way of perhaps seeing the synergies. Competition is not concerned about privacy per se, but it is concerned about privacy to the extent that it is a variable of competitions. There are now all the business models in the digital economy are very intensive in data accumulation. That's a concern for competition authority, because we don't see much differentiation in and then a competition authority is concerned when there is no much differentiation in the. So perhaps ensuring that markets are more contestable and that new business model can emerge is going to be good also for privacy, because then consumers are going to face more options, and perhaps we will see to how extent they value target advertising or not. They value they are, as Gloria saying, if it's not that they are paying with their data, it's that they have no option. It is true in the internet now. You can live without the internet, and then no, it's okay. But who can live without the internet today? So it's true that there are really. If one wants to know the result of a football match very quick, it's going to be impacted by advertising, and perhaps it's going to be targeted advertising. So yes, competition is not entirely concerned about privacy, but it's entirely concerned. And I think that if we ensure through competition policy, also through digital regulation, that digital markets have perhaps that markets are more contestable, perhaps new business model can emerge, and we'll see better results also in terms of data protection. So that was my cheesy message for wrapping up the conference.
Well, thank you very much to you all, and also to Alexandra, who has already left. As she has announced previously, because she needed to. So I think it's been a very interesting debate and a lot of fascinating questions. This will be kept online, so feel free to revisit it and to challenge any of the questions that have been debated. And thank you very much also to all the people attending it, and to all the people that will watch this panel after the fact on the YouTube channel of the Open University of Catalonia, Universitat Oberta de Catalunya. So thank you very much, and see you online. Bye to everyone.
Thank you.